Hello, friends. I am Cuauhtemoc Garcia Amor, a notary public in Acapulco, Guerrero, Mexico, and we were sharing a condominium law presentation. And my idea is that given we are living through all these COVID pandemic and we're all locked down in our homes, well, I created myself this job, to be uh, entertained and to share these concepts, and at the same time to help people that live within condominium units to improve their condominium culture, and that you could yourselves be able to manage your own condominium units, and that you will be fully aware of the rights that you hold within your condominium unit and in regards to your private property. So, well, as you know, we all know, as I was sharing with you in a given moment, and I shared with you in a previous presentation, human beings normally face economic situations regarding health or within their personal relations. And when we have a balance within the three lines, well, you do manage a stability, which is where we use our, for example, a condominium unit in a uh, tourist destination, and yet we do live in Mexico City, but we are unable to continue our payments. So my advice for you is do not embrace any obligations that you cannot face. And all of the obligations that we have, sooner or later, should be met. So my advice for you is that if you definitely are unable to pay for one of your assets, well, sell it, buy something smaller, and if you have something that is only for holiday purposes, sell it, and then, my best advice is that you will sell your condominium unit and stay at a hotel. We've got to be fully liable and responsible of our legal obligations, and that we should not become in under any moment into a delinquent situation. Let me share with you the executive civil uh, process that in order to get back the money that the condominium association had to pay in a given moment when any delinquent condominium owner was unable to uh, pay their maintenance fees or the different fees that are a part of the condominium management. Now, the Condominium Act in itself, once you buy a unit, this act is attached to the condominium bylaw. This is attached to the public deed that you get, and it is attached because this is what is stated by the condominium legislation. So, whenever you are given your public deed through which you can accredit the ownership of a new asset or a real estate property, as I have explained to you during my some of the first presentations, you will be a legal owner, and you will be co-owners of all the common areas within the condominium. This has to do with the maintenance fees, where you will be mandated uh, in regards to your bylaw to pay for all of these fees that have to do with paying for the operation of the condominium complex. So, uh, all of this group of intentions, such as the obligations that you acquire from the person that is selling the unit to you, the obligations that are a part of the bylaws through this public deed that you're getting, they will lead you to establish a mandate, it becomes the standard, and you are all obligated to comply with these already stated obligations within your contract. So, if anything is agreed within a condominium assembly, and even if you did not attend this assembly, that doesn't mean that you're not obliged to comply with what was decided within these assembly meetings. On the contrary, they are applicable generally to all owners. And as a matter of fact, we may say that in itself, it is a general obligation that any member, any owner of a condominium unit have to pay for the extraordinary fees, for a reserve fund integration, and that is actually what provides economically for the condominium responsibilities. If we don't do this, we will be having a depreciation of all of this. And finally, as I was telling you, many of the people in Mexico quite often it's difficult for us to pay taxes, and most of us have to pay property taxes. But you can always be fully aligned and pay what we need. And well, the principle here is we should never ask for a loan or any legal obligation because sooner or later we'll have to face it. You know, if you don't pay for it, you're acting as a dreamer because let's say you're not going to be paying your maintenance fees for the common areas in our condominium unit. That's silly in such a way that, of course, the different condominium associations and the condominium owners and the all the accords taken within the assembly will say, for example, there is a monthly or bi-monthly maintenance fee. Sometimes it's every 6 months, and even a yearly payment. The it ha- so then basically all acts, all condominium acts within the different states of Mexico state that after 3 months of delinquency in your maintenance fees payments, there is an article that authorizes you to, through the civil legislation, you can demand the delinquent to pay their fees. And with mercantile executive trials, to begin with, you have to seize the property, you foreclose it, and then through these mercantile executive trial, the creditor will certainly will not lose their money because, for example, if you lend money with a mortgage contract, well, you have to pay for the mortgage, and if you're delinquent in your mortgage payments, you are mandated to return to the creditor the asset. And if you don't do this, there is a mercantile executive procedure within the law, which is also a part of an IOU, for example, and therefore your goods are seized and then foreclosed to ensure that the debtor will not alienate or sell the asset and not to pay for the amounts that had to be paid. So I think that you must recall that if someone has an insolvency problem, there's no way of getting back the money that has been uh, subject of this situation. That's why it is a civil executive trial, because if they are informed that a process will be put in place, the first thing they're going to do is they're going to sell their unit. So that means that you cannot seize this unit and the process will not come up and then be able to sell out this asset. Let me be extremely brief here. Uh, uh, you have to recall that the fees are a part of the budget approved by the General Assembly at the condominium unit. They do become mandatory. Any agreement taken within the condominium assembly becomes a mandatory obligation. And even the civil code, in its Article 70, in the case of the Condominium Act for the state of Guerrero, well, I think you should also have a look at the Mexico City's legislation that is also uh, referring the same concept. It is also mentioned in its Article 43. And well, the idea here is that the maintenance fee payments are obviously for the maintenance of the common areas, such as swimming pool areas, the maintenance of the water pumps that will be directing the water to the reserve water tanks, so the whole condominium will have uh, water supply. So basically, it is dedicated to the common area maintenance. So having said this, the Act, the Civil Code in Article 3020, 211, uh, I'm sorry, it will mention that it is not only the amount payable, but also the legal accrued interest rates that are equivalent to 12% on a yearly basis. Let me say that my own personal experience as a notary public, normally when there is delinquency payments or delinquent payments from one of the condominium units, you wait for them to pay. You know, it's 3 months, 6 months, 1 year. There is a common understanding that anyone may have a medical emergency, a health problem, or a situation that prevents them from fulfilling their responsibilities and the payments that they have to face. But when the years go by, the general condominium assemblies, which, as you know, is the most important body within the condominium unit, uh, in the decision-making process, they will appoint a group of legal experts or lawyers in order to pursue through civil means the payment recovery and to start the trial that needs to be put in place. In order to start a legal process, the General Condominium Assembly must approve this. It has to be shared with the Assembly the amount payable regarding maintenance fees, extraordinary fees payable, and even if the amount for a reserve fund was created, we have to consider the total amount that this condominium owner is to pay and to realize how much they owe. And then the plenary assembly must allow the fact that if someone has a civil executive process in place that will have the intention of getting back all of these delinquent amounts because all the other condominium owners had paid for these previously, and what it is all about is that the condominium association should get back all of these money that the delinquent did not pay for in a given moment, but that the association of condominium unit owners is uh, mandated to pay for. Now, the authorization issued by the Assembly already has entailed the civil procedural action in accordance to Article 70 of the Condominium Act of the state. And I think that you have to look within your state local legislation, condominium legislation, to check which is the specific article that expresses that this particular action involves whatever legal action is to be promoted and presented before a civil court. Now, being things this way, the criminal and the civil procedural code state that for the purposes of being able to get back these fees, we need to present before the court the testimonial statement in which the assembly was formalized before the notary public and where the delinquent payment was presented and where lawyers are authorized to challenge for this payment. So this in itself is the element through which we will carry out the necessary legal action in the civil court. What uh, we may have a legal jurisdiction or different preparatory actions because most surely if you do not have the first testimonial as the act that has protocolized all of these concepts could issue a second testimonial and as a result of what will be contained by the assembly agreement these preparatory means or a volunteer jurisdiction that may be initiated in order to inform the delinquent condominium unit will give a limited time so they will know that the court process will be initiated and that to pay the fact of payment of his obligation is mandatory. Now we will get a second testimonial of how this second assembly process has been protocolized before the notary public, and that is how we will start the process that will be concluding with whichever unit that will be seized and where they will be selling this good that will be foreclosed, and if the delinquent uh, condominium unit does not pay for it, then it will be either be allocated to the condominium association or it will be eligible for selling. That is why it is very important to have a legal mandate and also a legal representation for civil trial processes. So the first element that has to take place is the non-payment situation. The fact that the condominium unit owner would not have paid for his responsibilities, that we will get to know what is the final amount that will involve not only the non-paid maintenance fees, extraordinary fees that have not been met, and also if there were, let's say, fees for a reserve fund, they also must be mentioned within this payment. Now, also, the moratory fees will be added, the delinquent fees will be added, and this is supported by the testimonial of how the assembly condominium assembly will be protocolized all of their actions. This protocol deed is the executive deed, and this executive deed is comparable to an IOU because, as I have mentioned, it is in itself a group of wills that, from its very origin, in the original selling deed that is acquired by the condominium unit, that is where we are mandating to comply with the maintenance fees, with the extraordinary fees, and with any additional amount that will have to do with the fact of payments regarding the condominium unit, to prevent its lack of maintenance or a loss of its value. So this is how the trial process starts and this is initiated, and the forced selling does not call for the authorization of the condominium unit owner. As a matter of fact, you will sell it to the best bidder, and with the amount obtained by this selling process, well, the condominium association will get back the fees and the amounts that the delinquent condominium owner did not meet. This is how the condominium association could have this uh, asset allocated to the condominium unit if they agree on any particular process here. In general terms, this is the civil executive trial process, which, as I have stated, is based upon the fact that from the very moment that the condominium owner acquires a condominium unit in this legal document attached to his public deed, he is mandated to pay all the fees that are agreed. And if you fall into delinquency, the mandate is to liquidate all of the amounts, the pending amount, the interest added to this, and that leads to the implementation of the civil executive court process for the debtor. In this case, it will be the condominium unit owner that has been a delinquent in this particular case. And before the civil court, there is an original testimonial presented of the assembly that is considered as the foundation document, which is the executive deed with which you will demand the debtor to comply with his obligations. Well, you have to recall that every condominium act is different within the different states, but it is in itself an executive trial process, as it is a mercantile executive trial or a civil executive element, which is what we are concerned with. Of course, we need to take into account that each judge, that each person has a different opinion. In the case that this executive protocolized deed before a notary public, where we are sharing the fact that there is an authorization coming from the assembly to go after the delinquent payments on behalf of the condominium unit owner. This is to be considered an executive element in order to start the trial process in regards to the debtor. You are to provide follow up to the whole procedure, perhaps within a higher court. So, with greater certainty, you may therefore continue with the full uh, implementation of collecting the amounts from the debtor. This is something that we may all fall into. We could become delinquent in any given moment, become insolvent, and what is really the negative element here is that we're not just insolvent, but if we are the owners of a real estate unit, of an asset, well, if there is, for example, a mortgage, uh, we can have a second and a third mortgage as long as we have enough elements to guarantee payment from the debtor. This is an example in the case of this mortgage situation that I share with you for you to understand it, such as, for example, if, let's say, like the owners of the Aztec Stadium and they owe $10 million and they ask for $1 million loan, well, later on, they may ask for a second mortgage or a third mortgage. And well, the same is applicable if this particular asset, if they have creditors, one, two, three creditors, well, they follow the same order, lining up in order to be able to get back their money. As long as the asset has is worth enough money as to pay their obligations. That's why we may consider that the condominium unit finally, even though the fact that they may be insolvent, they are still the owners of a good or an asset that will fully guarantee the recovery of the maintenance fees that in a given moment were not paid for. I hope I have been clear, and if you need to, you can certainly check my condominium book that you can get at my Notary Public. You can look for me within internet, within Google, and I will send you directly my condominium law book. It is really quite accessible, and I will eventually uh, put my book within Amazon, where you can also consult my other publications, notary law, the inheritance law, and also real estate uh, purchases, or where I talk about the domain transfer contract mandate and also mortgages. It has been a true pleasure to share with you, and I've been so pleased to have created these 7 segments regarding condominium law, and I hope this will be helpful to you. So we will have within our country a condominium broader culture of greater understanding, and that you will eventually uh, consider that my modest uh, conferences will help you to learn more about condominium law together with what you already know about. So thank you very much, and it's been a great pleasure.